Hi everyone. Before we start, I was just asked by Mr. Verma here if we'll be discussing the style of answering. So let me just first touch slightly on that, and that is the way in which I'll be discussing this judgment as well. So essentially, you will not necessarily be asked a direct question as to what the judgment says. It will be either analyze a certain aspect of the judgment or say, for example, if there's a dissent given in a certain judgment, then dissent has been how that dissent has been treated, or to analyze a march of law. It just don't expect that they're going to simply say for example, Republic of Italy versus Union of India, write a note on it. That's not how it's going to be. Maybe it can be whether the fundamental rights are available to non-citizens, discuss in light of the judgment delivered in Republic of Italy versus Union of India, or it could be, for example, say we had one question on interference by Supreme Court on in contractual matters. So in all of these cases, what you'll have to do is you have to first identify the issue that they're referring to, and they will also specify the case that you have to refer to specifically, the leading judgment that they've given in the list of 64. You briefly lay down the relevant fact. Do not sit down and write the entire fact. You will have the book with you, but please do not sit down and write the entire factual history of a matter, because it's a very lengthy paper. It's going to take a lot of time. Not everyone has the practice of writing that fast. So my suggestion is that write the relevant fact. The question of law regarding the question that's been asked to you or put to you in the exam paper, the treatment of that question of law and the follow-ups of it. Also, if there is any background judgment on the basis of which the judgment in question is coming. So, for example, say participation of a judge who has referred the matter to three-judge bench, as was done in Indore development. So in that case, of course, you can go back to history of AR Antule, etc., where this issue has already been discussed. And then if there are any follow-ups, you can give the follow-ups. That is essentially the long and short of it. Rest, I would say, please write and please practice writing, because we're all out of habit of it. I don't know about most of you. In my office, we don't use any paper at all. We're entirely electronic. So writing is a big task for all of us. Now, starting with the topic that's on table today, which is Republic of Italy versus Union of India. Most of you might remember back in 2012, there was an Italian ship called Ameyavikrama, which was crossing the Indian Ocean to go on to Djibouti. Now, there's an Italian law which says that there have to be Italian soldiers available aboard an Italian ship, which is essentially to protect them from piracy. Now, this entire belt of Indian Ocean, Somalia, Africa, Djibouti, etc., is infamous for piracy. And so to protect their staff, protect their vessel, protect their men and material, everything, the government of Italy had come up with this law, in accordance with which two soldiers, Massimo Laturi, I'm forgetting the name of the other one, were both present aboard this ship called Ameyavikrama. Now, while they were crossing Indian Ocean off the coast of Kerala, they see a fishing ship which is way beyond the 20 nautical miles that is the national territory of within the high seas of any country, and the fishing ship does not even have an Indian flag. Now, before we go ahead, a small note here on flag nation. Internationally, it is required that every ship that is traveling on the high seas will bear a flag of the country that it is registered in. So if there's a ship or a boat or a flotilla or anything that falls within the definition of ship under the Indian Merchant Navy Act, Merchant Shipping Act, will have to have an Indian flag. Now, this Indian fishing ship did not have a flag. So the Italian soldiers thought that this may be, a piracy trap, and they fired some shots. As it happened, the shots ended up killing two of our fishermen, and they didn't give much thought to it. They carried on forward. When they crossed about 38 nautical miles, they get a text, that they get an email and a telephone call from Cochin saying, please come back and please dock in. The moment they dock in, they're informed that an FIR has been lodged against them for murder, and the police is investigating, and the master of the ship is requested to kindly cooperate. Now, while this investigation is going on, police goes ahead and arrests the two Italian Marines aboard the Italian ship. Now, we must know that for our case, which is the one before Supreme Court, Italian Marines are referred to as P2 and P3. The P1, that is the first petitioner, is the Republic of Italy herself. Now, when they go to the High Court, while all of this is happening, they don't see. They go to the High Court saying, look, police here does not have any jurisdiction. This is a fight between two nations. And as is the deal with all sovereign disputes, this should be decided not by a state unit, but internationally. There has to be an international mechanism of resolving this dispute. The state of Kerala or the police in Kerala have absolutely no jurisdiction. High Court anyway goes on with the proceeding. There is a long pendency, and for the longest time, they're not delivering their judgment. So exasperated, these petitioners then come to the Supreme Court while the decision is still pending in High Court and file an Article 32 petition with threefold prayers, which if you have the judgments, you'll find at para 10, which is number 1, declare that any action by all the respondents in relation to alleged incident referred in para 6 and 7 above so-and-so under CRPC or any other Indian law would be illegal and ultra vires and violative of Article 14 and 21. So it must be appreciated how beautifully this prayer has been drafted, because even where you don't see a prima facie constitutional issue, there is a very, very important issue here, which is which are the fundamental rights that apply to non-citizens. Secondly, declare that the continued detention of P2 and P3 by the state of Kerala is illegal and ultra vires, being violative of principles of sovereign immunity. Another thing to underline, sovereign immunity and violative of 14 and 21 of the Constitution. Number 3, issue writ of mandamus and or any other suitable writ or order under 32 declaring the Union of India to take all steps as may be necessary to secure custody of P2 and P3 and make over their custody to P1, that is their country of origin, which is Republic of Italy. So these petitioners essentially base their entire arguments on 3 primary grounds. First was that P2 and P3 were discharging their sovereign duties. They are members of the Italian armed forces, and so they should be governed by public international law. Secondly, international disputes have to necessarily be settled between sovereign powers, between governments. So state units cannot be coming up and saying we have authority to take care of such and such dispute that has come up between, say, a state and an international unit, which, if anyone here is aware of the concept of investor-state disputes or WTO disputes, would know is not a good ground to take. Third platform on which they base their arguments was that in any case, if at all proceedings had to be initiated, they could be by Union of India and not by State of Kerala, because Union of India may still have jurisdiction well beyond 20 nautical miles, but State of Kerala has got no business doing so. So now, how did they substantiate their arguments? The first limb of the argument was regarding the scope of jurisdiction, is what they essentially harped on. First was they looked at the territorial waters, continental shelf, exclusive economic zone, and other maritime zones act. Now, what this act does, it identifies 3 zones beyond where your coast ends, which are territorial waters, contiguous zone, and exclusive economic zone. So territorial waters are where the limit of territorial waters is the distance of 12 nautical miles from the nearest point on appropriate baseline, which is Section 3 of the Act. Then Section 5 defines the contiguous zone, which is every line point of which is at a distance of 24 nautical miles from the nearest point of baseline referred. So till 12 you have your territory. Beyond that, another 12 you have contiguous. And then there is exclusive economic zone, which is the area beyond and adjacent to territorial waters, and the limit of such zone is 200 nautical miles from the baseline referred to subsection 2 and 3 above. Then there is, of course, the concept of contentious shelf, which is not important. So anyway, the argument was that India does have jurisdiction. The Union of India definitely has jurisdiction till about 200 nautical miles, but the state of Kerala does not have the jurisdiction to exercise police powers so as to ask somebody to return from high seas, come back, dock into Kochi, and then initiate criminal proceedings against them. So the petitioner urged that the incident occurred in the zone in which central government is entitled, not the state government. The Act nowhere contemplates conferral of jurisdiction on any coastal unit forming part of any maritime zone adjacent to its coast. Then you must all, I'm sure, already know the United Nations Convention on the Law of the Seas, which is the primary international law governing relations of nations who are high seas. Now, the UN clause, what it provides for is something called as innocent passage. Innocent passage is that when one ship of a foreign nation is crossing through territorial waters of another country without harming or affecting in any negative way the territory or territorial assets of that country, it should be allowed to pass peacefully. And the contention of the petitioners was that we were merely innocently passing. We were under a misconception that these are pirates and we shot. And at any rate, we were doing our sovereign duty. So under the UN clause, you should not be prosecuting us. And besides that, UN clause also provides for ways to resolve international disputes. So instead of state of Kerala initiating police proceedings, it should have been the Union of India somehow finding a solution under the international legal regime. There's also an important concept of high seas here. See, again, the ultimate, all of these different aspects ultimately culminate into a big argument of what is the extent to which the state police can exercise its power. So at no point, it is very interesting to note that at no point does the Republic of Italy say that India does not have jurisdiction. All it said was that the state of Kerala does not have jurisdiction. So central government could as well have taken steps. But the question then is, what was the law under which the central government could have taken steps? Or did there exist any authority on which central government could have mobilized? Because as we know, under IPC, it is the local jurisdiction. And it was the person of Kerala who was killed. So how could the central government have initiated proceedings is the big question to mull over. Anyway, to buttress their argument, petitioners also relied on a previous judgment of the Supreme Court of 2008, which is Aban Lloyd Chile's Offshore Limited versus Union of India. Now, this is an interesting case where what had happened was that there was an offshore unit which was importing materials and not paying any custom duty, but using it, saying we are a ship in international waters. And the court held that no, you are within the exclusive economic zone of India, and India has all rights within this zone to protect its economic assets, and so you have to pay the customs duty. So again, the petitioner is saying that, look, the central government very much had the right within its exclusive economic zone, which is 200 nautical miles, to have taken any action that it needed to take to protect its assets, to protect its people. But the state of Kerala, which is just a mere small federal unit of the country, could not have initiated the proceedings that it did. This is the long and short of the arguments that were placed by the petitioner. Then we go on to the arguments raised by the respondent, that is Union of India. What Union of India did was that it identified only two issues. It says that all of this that the petitioner is saying need not be gone into. If you look at para 52, the judgment has culled out. And to Justice Kabir's credit, I must say that he has reproduced the factual background and the arguments very well. Of course, in the larger scheme of things, if we see the supplementary judgment of Justice Chelameshwar seems to answer the legal questions more clearly. But far as understanding the brief of the case, understanding the arguments that were raised, I would say you must give a read to Justice Kabir's opinion. So in para 52, union's issues have been culminated. So union, instead of replying directly, raised its own issues, saying that number one, Indian courts have territorial jurisdictions to try P2 and P3 under the IPC. And number two, whether the writ petitioners are entitled to claim sovereign immunity. Now to this, what the union said was that the legal position with regard to India exercising its jurisdiction has been laid in Aban Lloyd, which is the same case that the petitioners rely on. And we say that our federal unit is essentially us. So, I mean, the federal unit of union is the union itself. So they're relying on Aban Lloyd and Gramophone Company. It was argued that even in the absence of municipal law, treaties have to be treaties can be used as the law to base our actions on, and the contiguous zone, because under the treaty it is considered as part of the territory of India, CRPC and IPC will very much extend to it. Then to determine the issue of territorial jurisdiction, union argued that it would be necessary to read section 2 of the IPC and the Maritime Zone Act, and there was a notification issued in 1981 wherein the jurisdiction had been slightly extended. So union says you have to read IPC, you have to read Maritime Act, you have to read UN clause, all of this together. Only then can you come to a clear picture, because otherwise UN clause will say that you go to an international body to settle your dispute. So, okay, at this point, just a segue, UN clause provides for arbitration. UN clause also provides for a tribunal called ITLOS, which is International Tribunal for the Law of the Sea. So there are these two mechanisms under UN clause to resolve disputes that may arise at high seas or disputes that may arise relating to shipping incidents. Maritime Act, as the petitioner was trying to rely on, would a broad reading of it would say that state unions do not have the jurisdiction. It is the union. It is the entire Union of India that has jurisdiction to protect its territorial and exclusive economic zone up to about 200 nautical miles. On the other hand, IPC says that the jurisdiction extends even beyond territory of India if a crime has been committed by an Indian or against an Indian. So we must first look at this IPC provision. I would recommend that you go back and whenever you're reading this judgment, do keep the IPC next to you, especially section 2 and section 4, because it very clearly says that the jurisdiction of India lies beyond the territorial limits of the country in certain cases. Personal opinions aside. So then, anyway, coming back to the case, the main case of Union of India is that a plain reading of Section 7 of the Maritime Act and a contextual interpretation would be that the Republic of India has jurisdiction, and therefore the state of Kerala was not wrong in initiating criminal proceedings against the Italian Marines. Then the Union also looked at UN clause specifically, of which they look at Article 97. Now, what does Article 97 read is, it deals with penal, I'll quote, penal jurisdiction in matters of collision or any other incident of navigation. Now, the question is, what is this and any other incident of navigation? Would it include somebody shooting? Because the convention doesn't clearly say so. And the union's argument is that the convention at no point contemplates homicide within any other incident of navigation. Because you see, killing somebody or shooting someone has got nothing to do with navigation. It's a completely different aspect. It is, even in this case where shooting happened, it had got nothing to do with losing track. It was all to do with piracy. And there are different laws that are governing piracy in high seas. Then the second limb of union's argument was that the petitioners do not have sovereign immunity. Now, I would say that you flag para 73 for this, because the union produces a very interesting quote by Lord Denning, where he says that the doctrine of sovereign immunity is based on international law. It is one of the rules of international law that a sovereign state should not be impleaded in the courts of another sovereign state against its will. Like all rules of international law, this rule is said to arise out of the consensus of the civilized nations of the world. All nations agree upon it, so it is part of the nation, part of the law of nations. However, Lord Denning went on to observe that notion of a consensus was merely fictional and that there was no agreed doctrine of sovereign immunity. So you see, union's argument is that yes, there is a concept of sovereign immunity, but what exactly is it and to what extent is it practically applicable? There is no clarity whatsoever on it. Also, we must remember that these soldiers were aboard a private ship. Enrica Lexi was not a Italian vessel, a government-owned vessel that was carrying out some sovereign function. Then there is a third party, which is a very important party to this, which is State of Kerala, whose arguments were also recorded. And State of Kerala more or less repeated what the union said, that under the Maritime Zone Act, because the territory of India extends up to the exclusive economic zone, the police of any of that coastal state is bound to have the authority to carry out investigation and check crime, if any, that occurs within that zone. Let us now come to what the court really held. The court says that under Article 19.4 of the UN Clause Convention, it is the flag state which shall carry out the inquiry, which is, as I said at the beginning, every ship carries a flag of the nation which it is registered in. So, for example, Enrica Lexi was carrying the Italian flag, so it was an Italian ship. So, under Article 19.4 of the Convention, which deals with duties of flag state, Clause 7 provides that each state shall cause an inquiry to be held into every marine casualty or incident of navigation on high seas involving a ship flying its flag and causing loss of life or serious injury to nationals of another state. It is also stipulated that the flag state and other state shall cooperate in the conduct of an inquiry held by that other state into any such marine casualty. So, court is very clearly with the petitioners on this point that it has to be between the nations and not the state. Coming to the question of IPC, the court says that, of course, applicability of Section 4 is no longer in question, in this case on account of concession made on behalf of State of Kerala in writ proceedings. However, Section 2 of IPC provides otherwise. Undoubtedly, the incident took place within the contiguous zone over which, both under the Maritime Act and under the UN clause, India is entitled to exercise rights of sovereignty. However, as decided by this court in Aban Lloyd, Subsection 4 of Section 7 of the Maritime Act only provides for Union of India to have sovereign rights limited to exploration, exploitation, conservation, and management of natural resources, both living and non-living, as well as for producing energy from tides, winds, and current, which cannot be equated with rights of sovereignty over the said areas in exclusive economic zone. So the court goes on to essentially give an interpretation to Section 7, subsection 4 of the Maritime Act, saying that even where the government does have jurisdiction, it is only to a limited extent of exploration, exploitation, conservation. It is economic rights that you have. You do not have police rights in those areas. So what therefore transpires is that while India is entitled both under domestic law and public international law to exercise sovereignty up to 24 nautical miles from the baseline on the basis of which the width of territorial waters is measured, it can exercise only sovereign rights within exclusive economic zone for certain purposes, not for all purposes. And that is the distinction which is very, very essential for this case. The incident of firing having occurred within the contiguous zone, Union of India is therefore entitled to prosecute the two Italian Marines. However, the same is subject to provisions of Article 100 of the UN clause. So, while holding that state of Kerala has no jurisdiction to investigate this, the incident, the court also holds that Union of India still does have the jurisdiction, and they can very well carry out investigation against these two Marines and bring them to justice. And to that end, court exercised its powers under 142 and requested the Chief Justice and the President to establish a special court to look into this matter. This was the opinion of Justice Kabir. Now, if you would remember initially what the prayers were of the petitioner was to declare that these actions that the respondent, that is the Union of India, has been taking are violative of Article 14 and Article 21 of the Constitution. This is an issue that Justice Chelameshwar deals with in his opinion, where he discusses how Article 14 and 21 are also available to aliens and to non-citizens. And he holds that because these are constitutional guarantees, they must be secured, and the union must take care that these individuals who are foreign nationals are not discriminated against merely because they are non-citizens, merely because there has been a loss of life on the Indian side. So in para 133, the judge says that protection of Article 14 and 21 of the Constitution is available even to an alien when sought to be subjected to the legal process of this country. This court on more than one occasion has held so on the ground that rights emanating from these two articles are not confined only to or dependent upon the citizenship of this country. As a necessary concomitant, this country ought to have the authority to apply and enforce laws of this country against the persons and things beyond its territory when its legitimate interests are affected. In assertion of such a principle, various laws of this country are made applicable beyond its territory. Now, also very interesting, one point which is different from Justice Kabir that Justice Chelameshwar raises is there's an old English jurisprudence principle which, as it happens, India up until the Italian Marines case was certainly following, which was that all crime is local. The jurisdiction over the crime belongs to country where the crime is committed. But he adds a good caveat, which is, but that the principle is not accepted as an absolute principle anymore. The increased complexity of modern life emanating from the advanced technology and travel facilities and the large cross-border commerce made it possible to commit crimes whose effects are felt in territories beyond the residential borders of the offenders. Therefore, state claim jurisdiction over number one, offenders who are not physically present within, and number two, offenses committed beyond the territory of state whose legitimate interests are affected. So that is largely the issue. Also, one final point that Justice Chelameshwar notes, but Justice Kabir doesn't, which is regarding the analogy of the facts of present case to hijacking. So he says that Parliament has asserted, for example, talking about asserting your authority in areas which are beyond your territory. So, for example, in case of hijacking, under the Anti-Hijacking Act, the Parliament has asserted authority to apply penal provisions against persons who hijack. So they are people of other nations. Of course, another nation is say that these are stateless people, these are stateless elements. But we do know that ultimately everybody has a nationality. So the Act expressly recognizes the possibility of commission of an act of hijacking outside India, which may affect Indian people, and the state of India will have all the rights under that Act as well as under the Geneva Convention Act to try such a criminal and to bring him to justice. So I think that is where I will end it with just saying that they also gave a slew of directions whereby these soldiers were to be removed from Kerala and brought to Delhi. They were to report to the police station in Chanakyapuri, and the government of India was to take immediate steps, and the Italian embassy was also to take responsibility of these Marines. Now, what is to be seen from here is from the point of view of exam. Number one, this is important for application of Article 14 and Article 21 to non-citizens. Number two, this is another issue that is worthy of seeing is, can a 32, which is more a practice and procedure question, which is, can a 32 petition be filed when proceedings are pending before the High Court? Clearly they can. And number three, whether Parliament has the power to make laws that would extend beyond the territory of your country. These are the three important legal points on the basis for which this judgment is important. I don't have anything more that I can add without questions here. If anyone has any questions, you may please ask.
Yeah, people can unmute themselves and ask questions.
I don't know. I'm flattered. Maybe I cleared all the doubts. I can maybe give you guys important paragraphs for this judgment to look at. That helps. So I would say para 10, para 14, 17, 21, 25, 26, 27, 28, 29, 30, 33, 35, 41, 42, 47, 52 is important, very, very important. 55 and 50, 55 to 59, 61 to 63, 71, 73, then 80, 81, 82, 83, 86, 90, 93, 95, 96 to about 100, 107 to 111. This is Justice Kabir's opinion. Then in Justice Chelameshwar's opinion, you could mark 123 to 120 to 138. then also 141 to 148. And then para 151 are the final directions that the court issued. That's it, I guess. Pradyuman, should we call it a
Yeah.
close?
Any questions? I think we should give people like last 1 minute to think if there is some doubts which are boiling up and they want to get.
I think there are no doubts. It's a lot of reading and a writing practice, which we are anticipating now.
That's definitely.
That is going to be there, but rest assured, it's not too much writing. Please do not end up. I would really give a cautionary point here. Please do not just think that you're going to write more and you're going to get more marks. Stick to the basics, stick to the point, make sure whatever it is that needs to be conveyed is conveyed. Do not write. This is not a university history exam where you have to fill papers. That is not the criteria of getting marks in this exam. The criteria is to make sure that you write what is asked of you.
Correct.
So don't waste too much time, I would say. Give yourself, maybe divide your 3 hours into 5-6 number of questions and then attempt it. And if you can write in points, nothing like it, because that's going to convey your answers better. So that's all I've got to say. Nothing else. Thanks.
Thank you.
Thank you. All right. Thank you, Pradyuman.
Yeah, thanks, Ameya, for doing this webinar. Right. We hope to see you more and more on EBC Learning webinars and otherwise as well. Okay. Thank you. Thank you very much.
Thank you. Bye-bye.